businesses, check whether they are following data rules properly or not. They will provide you legal support. Organization can get expert assistance on data protection regulations. They help businesses identify and manage privacy risks before they become serious issue. For small and medium enterprise SMEs, SDAIA also offers a regulatory sandbox for data and privacy. This sandbox allows businesses to test their data practices in a safe and controlled environment. You can get expert guidance on how to handle personal data. It ensures compliance before fully rolling out their data-related operation. So in simple terms, this platform, National Data Governance Platform, and the regulatory sandbox are designed to make it easier for businesses to follow the rules, reduces risk, and build trust with customers when handling data. Public consultation platform, what this platform is about, we also called it SDAIA. It's an online platform run by the National Competitiveness Center, designed to make this law making process more open and more transparent before new laws and regulation approve. SDAIA allows everyone, whether you are a member of the public or you are part of any government agency or from a private company.
Welcome to Global Information Security Society for Professionals of Pakistan.
Welcome to today's session on understanding Saudi Arabia data privacy PDPL law in the simplest and most practical way possible. This session will take about 1 hour 30 minutes to like 1 hour 45 minutes, but I will try to give you a clear understanding of the key articles. I'm sure that this session will be very useful. We are recording this session and it will be available on the GISPP YouTube channel along with the links shared in today's session. So stay tuned. My name is Syed Arsalan and I'm working as a cybersecurity consultant. I had little experience in IT audit, and currently I'm also working in some engagements related to data privacy and protection. Working in Riyadh, so feel free to connect me over LinkedIn. Okay, before we begin, I want to emphasize that this session is for general awareness only. It is not the legal advice. If you need specific guidance or compliance assistance, you can please consult your legal expert or any data protection officer. The Global Information Security Society for Professionals of Pakistan is here to provide knowledge, but we are not responsible for any actions taken based on this session. Also, any names of bank, companies, or individuals mentioned today are purely for educational purposes and do not represent actual organization. What we will discuss in today's session, today we all cover a lot of ground. Here's what we all discuss. We will see what does PDPL protect, what are the consequences of non-compliance, what is the cause of data breach by industry in Saudi Arabia, who is SDAIA and its objective, who is NDMO, what are the regulatory arrangements SDAIA made till now. We can further see this law enhancements over time. We will see further the applicability and scope of this law. We will see what are the compliance tools, what is public consultation platform. And then from slide number 15 to 57, we will see PDPL articles from 1 to 43 with simple examples. So let's start our session. What does PDPL protect? Our personal data, whether we realize it or not, our data is collected, stored, or used every day, from online shopping to hospital records. So, but how do we ensure that our information is protected? So that's where the Saudi personal data protection law comes in. This law is designed to safeguard our personal data, any information that can identify us, such as our names, phone numbers, or ID numbers, but it goes even further. It also protects sensitive personal data, including our health information, biometric data, genetic data, our religious beliefs, our political belief. So this type of data is highly private, and PDPL ensures it handled with extra care. And as individuals, we have rights when it comes to our data. And under this law, personal data protection law, you and we have the right to access our personal data and know how it's being used. We can request about the corrections of the data if it's incorrect. We can ask for the data to be deleted if it's no longer needed. We can object to certain ways your data is being processed. We can see further. We can transfer our data to another service provider when necessary. Consequences of non-compliance: if an organization in Saudi Arabia fails to comply with data protection regulations, the consequences can be severe. First, there are serious legal consequences. This includes heavy penalty, fines, and even sanctions that could significantly impact the company operations. Then we have a financial and reputational damage. Not only do direct fines hurt the bottom line, but there are also indirect losses. Customer loses trust, and once that happens, it's difficult to rebuild. Cost of data breach by industry in Saudi Arabia. Data breaches can be costly in Saudi Arabia. The costs vary by industry to industry. For example, the financial industry often faces higher costs due to the nature of the data they handle. So, and then we have a industry, healthcare data. So it's crucial for businesses to invest in a robust data protection measures to avoid these costs. Who is SDAIA and its objective? SDAIA is the competent authority in Saudi Arabia. It stands for Saudi Data AI Authority. Its main objective, it's the main organization in Saudi Arabia responsible for data and AI, including big data. Its headquarters is in Riyadh, and it's directly reported to MBS. And SDAIA has three main divisions usually. One is NDMO, we called it National Data Management Office, then National Center for AI, and then National Information Center. So its objective includes, it sets the rule for data and AI, it improves the country data capabilities, and making Saudi Arabia a global leader in a data-driven economies. About NDMO, NDMO is National Data Management Office. It's a part of SDAIA. It focuses on managing and improving data in Saudi Arabia. NDMO usually develops plans and rules to help organizations handle data. It ensures national data is digital and protects personal information by setting and enforcing rules. This office goals includes, it develops and share rules, policies, standards for data and AI. It also suggests ways to use national data efficiently and generate revenue. It also monitor how well government agencies follow data rules and protect personal information. SDAIA regulatory arrangements. SDAIA, the competent organization in Saudi Arabia, has put several laws and regulations to ensure strong data protection in Saudi Arabia. These regulations help organizations comply with this law, PDPL, and safeguard personal data effectively. For more details, you can always check the SDAIA website. Plus, we all be uploading this session on the GISPP YouTube channel, along with all the important links for easy access. And they created different regulations. It's very hard in today's session to cover all the instructions or all the guidelines, but we will definitely see these all black bold topics in our upcoming session. Like they talk about how you can appoint personal data protection officer, how you can license a data protection audit firm. Then there are some binding corporate rules. Then there are some standard contractual clauses they talk about. Then how you can destruct, anonymize, and pseudonymize guidelines on personal data. Then there are some breach incident response. So we will definitely cover in our upcoming sessions. Today, our main focus is to just understand the key articles of this law. Okay. So PDPL key timelines. Let's look at the key timelines for the PDPL. Originally, PDPL published in 24th of September 2021. Then this original PDPL suspended on 24th of March 2022. Again revised PDPL version approved on 27th of March 2023. Then it's enforced on 14th of September 2023. Then 1 year of implementation period given by SDAIA. And yes, enforcement begins on 14th September 2024. So this timeline shows the evolution of the PDPL and gives organizations time to prepare for compliance. Scope of PDPL, it applies to all sectors that handle personal data in Saudi Arabia. It includes private sector, businesses, and organizations like retail, healthcare, and education comes under it. It also applies to public sector, the government entities that handle personal data. So this means that any organization processing personal data in Saudi Arabia must comply with this law, personal data protection law. So in short, this law applies to all sector, private and public. Okay, what are tools and support for data protection? Okay, there's the competent authority SDAIA provides a centralized platform. We called it National Data Governance Platform. It's a centralized system provided by SDAIA, and it helps organizations stay compliant with the data protection. Through this platform, user can access they help the businesses check whether they are following data rules properly or not. They will provide you legal support. Organization can get expert assistance on data protection regulations. They help businesses identify and manage privacy risks before they become serious issue. For small and medium enterprise SMEs, SDAIA also offers a regulatory sandbox for data and privacy. This sandbox allows businesses to test their data practices in a safe and controlled environment. You can get expert guidance on how to handle personal data. It ensures compliance before fully rolling out their data-related operation. So in simple terms, this platform, National Data Governance Platform, and the regulatory sandbox are designed to make it easier for businesses to follow the rules, reduces risk, and build trust with customers when handling data. Public consultation platform. What this platform is about, we also called it Istatla. It's an online platform run by the National Competitiveness Center, designed to make this law making process more open and more transparent before new laws and regulation approve. Istatla allows everyone, whether you are a member of the public or you are part of any government agency or from a private company, So you can review and give feedback on proposed law. So the goal of this platform, it gives people a chance to share their opinions and suggestions on new laws. It ensures the lawmaking process is clear and open for all to see. It helps create stronger, more effective regulation by using input from those who will be affected by them. So by bringing feedback from all sectors, this platform make sure that the new laws are well designed, practical, and beneficial before they become official. Okay, so let's start from article number 1. We have a few definition, and it's very, very important to understand these definitions in order to understand further articles. So personal data is any information that can identify a person directly or indirectly. I'm repeating again, personal data is any information that can identify a person directly or indirectly. This includes the names, you can say ID numbers, your contact details, photos, and sensitive data is a type of personal data that requires extra protection. It includes your health data details, your genetic details, your religious beliefs, your political beliefs. Processing personal data means any action performed on personal data, whether manually or through any automated system. So this includes any collecting or storing or modifying or sharing the data. Then we have two terms, controller and processor. We use very much in data privacy world. So a controller is an individual, is organization or a government entity that decides why and how personal data will be processed. I'm repeating again, a controller is an individual, organization, or government entity that decides why and how personal data will be processed. Processor is an individual, organization, and government entity that processes personal data on behalf and as instructed by the controller. Data subject is the person whose personal data is being collected or processed. In other words, is the individual that the data is about. Public entity, it's a government-related organization in the kingdom, such as ministry, any government department, any public institution or public authority. Collection is the process where the controller gather personal data. This can be done directly from the data subject, their representative, their legal guardian, or any other source. Competent authority in Saudi Arabia, it's SDAIA. The other two terms are pseudonymization and anonymization. Very, very important term. We can understand it with some example. Like think of pseudonymization like giving someone a nickname instead of their real name. So the real identity is hidden, but if you have a secret key, you can figure out who they are. And anonymization is like erasing the name completely so that no one can ever tell who the person was. So no matter what, there's no way to link the data back to the person. So pseudonymization hides identity but can be reversed with extra information, while anonymization makes identification impossible. Pseudonymization is usually used when we still need to work with the data but want to protect identities. Pseudonymization is used in healthcare industry where patient names are replaced with some code so that doctors will still analyze medical records while keeping identities hidden. Pseudonymization is used in financial transactions. Bank data is pseudonymized for fraud detection without exposing personal details. We can use pseudonymization in research and analytics. Companies study customer behavior without directly knowing who each person is. Anonymization is used where there's no need to identify people at all. Anonymization is used in public health reports where disease statistics are shared without any personal details. Anonymization is used in open data and research. Governments and organizations release data for public use without any chance of identifying individuals. We can use anonymization in employee surveys. Companies collect honest feedback without linking responses to employee. So, in short, pseudonymization hides identity but can be reversed. It's reversible, while anonymization makes identification impossible. Article number 2 talks about where the law applies. It states the PDPL applies to personal data of people in Saudi Arabia, even if the data is processed outside the country. It also covers about diseased individuals if it can identify them or their family members. However, the law doesn't apply to personal data used for private or family purposes unless it's shared or made public. Article number 3 is about no conflict with others law, means that PDPL does not affect any other law or agreement that provides individuals with more rights or better protection for their personal data. For example, if you are a WhatsApp user in Saudi Arabia, but also a European citizen, so your data is protected under both the PDPL and the GDPR. If the GDPR offers stronger rights, WhatsApp must still comply with those. Article number 4 talks about the rights of the data subject, rights to be informed, right to access, right to correct data, right to delete data. Right to be informed means that companies must tell you why they are collecting your personal data and how they plan to use it. So people should know what's going to happen with their information from the start. People have the right to see what personal information companies have about them. If they want to know what data is being stored, they can ask to see it. And if there's anything wrong or outdated in the personal data, people can ask for it to be fixed or updated. For example, if your contact details are wrong, you can ask to update them. When the data is no longer needed, or if someone doesn't want their data to be kept anymore, they have the right to ask for it to be deleted. So these rights give people more control over their personal data and how it's used. Consent for article number 5 talks about consent for data processing, states that personal data can only be processed or its purpose changed with the consent of the data subject only. Consent can be withdrawn at any time. For example, if a bank asks for your consent to process your data for a loan application, and you can withdraw that consent later, and the bank must stop processing your data for that purposes. Article number 7 talks about consent cannot be a condition for service, means consent for data processing should always be fair and optional, not forced, unless it's directly needed for the service. For example, if there is a bank asks for your location to help you find the nearest ATM or branch, that makes sense because it's a part of the service. But if the bank says you must agree to share your location for marketing and ads, or you can't use online banking, so that's not allowed. Why? Because sharing your location for ads has nothing to do with checking your balance or making transactions. So in short, your consent should only be required when it's truly necessary for the service, not for extra things like marketing or some other purposes. Article number 8 talks about the responsibility of the controllers in choosing and monitoring processors. When a company controller collects personal data, it often works with other companies' processors to help process their data. The controller, here's the key rule: the controller is always responsible for protecting the data, even if the processor makes a mistake. For example, we had a very famous bank here in Saudi Arabia, Al Raji. And for example, if Al Raji Bank hires processors like Imkan or Your Pay to process transactions, and if, for example, a data breach happens at processor side, so in that case, the bank is still responsible. So it must make sure that any company it works with follow data protection rules. That's why businesses must choose processors carefully and regularly check that they handle data safely. Article number 9 talks about limitation on access to personal data. It gives company the right to set the time limits for data access requests and restrict access in certain situations to protect people or national security. For example, if there's a bank, it allows customer to see their personal banking data like account details or transaction history. So you can request access to your data, but only within a certain time frame. If your account is under some fraud investigation, might be the bank or any organization may temporarily block access to prevent anyone from changing or tampering with the data. Or if the government is investigating a major financial crime, so the bank may temporarily prevent access to certain data to protect national security. So this article is to ensure a balance between your right to access your data and the need for security and protection. Article number 10 talks about the conditions for collecting and using personal data. Controllers must collect your data directly from you and use it only for the intended purposes. However, there are certain cases where data can be collected from other sources or used for different purposes. It includes with your consent if you are agree, from public available data, information that is already public or obtained from public sources, or from a government use when a government entity need it for public interest or for any security, legal, or for any judicial reason. It includes the vital interest if collecting data directly from you could harm cause or impact your well-being, when it's essential to protect lives, or if the data is stored in a way that does not identify you. So these exceptions help balance privacy protection with practical needs, ensuring that the data is handled responsibly while allowing essential services to function. Article number 11 focuses on how companies should collect and handle your personal data to ensure it's safe, limited, and used for specific purposes. For example, let's take an example of some bank here. Let's take example of Bank Alinma. So if any bank uh, follow it, they should follow the rules, like they should follow the purpose of data, like why they are collecting your data, how data is collected, what data is collected, what is the data retention period. Okay, so in simple terms, the bank only collects what needed, keep things clear, and doesn't hold on to your data longer than necessary. So the purpose, the four things should be very, very necessary. I'm repeating again, the purpose of data, how data is collected, they must do it in a clear and a secure way. There should be no hidden details or confusing terms, and they can't force you to provide unnecessary information. And what data is collected, and it also talks about the data retention period. Article number 12 is about privacy policy requirement. It says the company must have a privacy policy that clearly explains how they handle your personal data. Here's what the privacy policy should cover, like why data is collected, like the company should tell you why they are collecting your information, like if it's for opening an account or like making payments or providing a service. What data is collected, they should list exactly what kind of data they are asking for, like your name, address, or phone number. How data will be processed, the policy should explain how they all use your data, whether it's to provide services or to improve customer experience or for security purposes. This privacy policy requirement should talk about your rights. It should also let you know what rights you have when it comes to your data. Like, do you have right to access your data? Do you have right to correct it? Do you have right to delete it if you don't want it? So in simple terms, a privacy policy is there to help you understand how and why your data is being used and what you can do about it. Article number 13 talks about information during data collection. It requires controller to inform data subjects about the purpose of data collection, like who will see their data, and the risk of not providing the data, like why your data is being collected. For example, in case of bank, they will explain the legal reasons for collecting your data. They will tell you about the purpose and necessity. The bank will clearly state why they are collecting your data and let you know why information is mandatory to provide and which is optional. They also ensure that your data won't be used for any other purposes unless for some specific reason or allowed by law. You will be informed about who is collecting your data and how to contact them. Uh, they will also tell you which third parties will receive your data, whether they are inside or outside the kingdom, and how they will use it. They will use it. What might happen if you choose not to provide the requested information. You all be informed about your rights regarding your data, such as the right to access, correct, or delete. Article number 14 talks about data accuracy and relevance, says that the company must make sure that the personal data they collect is correct, complete, and up to date. If any information is wrong, it must be fixed before they can use it further. So, for example, when a bank collects your data to open an account, they must check that everything is accurate, like your address or a phone number. If any of your details are wrong, they need to verify and correct them before moving forward with the account setup. So simply put, if your data is incorrect, it must be fixed before the bank can use it for anything further. Article number 15 talks about conditions for disclosure of personal data. Organization controllers cannot share your personal data unless certain conditions are met. So here are the key situations when sharing is allowed. If you have only agreed to it, means with your consent. If the information is already public, or when a public entity needs the data for public interest or for any security, legal enforcement, or judicial purposes. If sharing is necessary to protect lives, public health, or safety, or when the data is processed in a way that ensures no one can identify you, and if it required for business purposes without harming your rights and without involving sensitive data. Article number 16 talks about restrictions on disclosure of personal data, means when is sharing personal data prohibited. So under this law, organization or controller must not disclose personal data if it could cause harm or violate legal obligations. Data must remain protected. If sharing would cause threatens any national security, it damages any international relationships, if it interferes with justice and law, if it endangers any personal safety, if it affects vulnerable individuals, or if it breaks professional ethics and if it defies legal orders. So this is about the controller must not disclose personal data under those conditions. Article number 17 is about notification of data corrections. If any personal data is corrected, completed, or updated, it is the responsibility of the data controller to notify all other organizations that have received this data. They must ensure that these organizations are provided with the updated information, ensuring accuracy across all systems. Let's take an example. For example, let's say a healthcare provider has a patient address on file. If the patient moves to a new address, the healthcare provider must update the address in their records. Additionally, they must inform other organizations that have received the patient's data, like insurance companies, so that the companies have the correct or updated address. Article number 18 is about retention and destruction. It requires controllers to delete personal data when it's no longer needed unless there's a legal reason to keep it. For example, if a bank makes changes to your personal data, they must notify any third parties who previously received your incorrect or outdated data. Article number 19 talks about data protection measures, requires controller to take all necessary steps to protect personal data, including during data transfer. This includes using encryption and all security measures. For example, if a bank must ensure that when transferring a customer personal data, such as during an online banking transaction, the data is protected. So this could involve using encryption technology or secure networks and access control to prevent unauthorized access or breaches. Article number 20 talks about breach notification. It requires controller to notify the relevant authority and affected individuals in case of data breach. For example, if a breach occurs, the controller must inform the authority within 72 hours. Article number 21 talks about the response to data subject requests, says the companies must respond to your request about your personal data within 30 days. For example, if you can ask for a copy of your personal data to see what information they have about you, you can ask them to correct your any mistakes in your data or even delete if it's no longer. You can ask for your data in a format that's easy for you to move or use somewhere. If you don't like how they are using your data, you can object and ask them. So basically, if you want to know, update, or even remove your data, the company must get back to you within 30 days. Article number 22 talks about impact assessment for data processing. So when a company collects or processes your personal data, they must assess how this might affect your privacy. So this is called a data protection impact assessment. It's important because it helps the company identify potential risks before they happen. Like, is this data collection necessary? Does the company really need this personal information they are asking for? Is it following the rules? Are they handling your data in a legal and safe way? How can they reduce risk? What steps can be taken to protect your information for being misused? So like these sort of questions will be covered in data protection impact assessment. So let's take an example. If a bank is planning to create a new mobile banking app, so they would do a data protection impact assessment to make sure the app doesn't ask for more personal detail than needed, like unnecessary access to your photos or contacts, that your data is kept and that they are following the rules. So thus, data protection impact assessment helps the company make good decision. It avoid mistakes and keep a record of how they all handle your data safely and responsibly. Article number 23 of PDPL talks about health data processing control. It set rules for handling health data, such as limiting access to only those employees who need to provide health services. For example, we have very famous insurance company in Saudi Arabia. We call it Bupa. So Bupa Arabia Health Insurance, these rules means limiting access to health data like medical file to only the essential staff needed for providing health services or managing insurance. So the company would ensure only the minimum number of employees handled health data, protecting customer privacy and complying with the law. Article number 24 talks about credit data processing controls. When it comes to credit data, there are strict rules to protect your privacy and ensure compliance. Here's what organization must do. They would always ask for two things. Number one is explicit consent, and number two is transparency in data access. Explicit consent company must take clear steps to confirm whether you are agree to the collection, usage, or sharing of your credit data. For example, when you add a credit card to a Google Pay, the app must ask for your explicit consent before sharing your data with the issuing bank for verification. And if Google shares your credit data with third parties like payment processors, you need to be informed. The other part is transparency in data access means when an organization requests access to your credit data, you must be informed. For example, when you apply for a loan through a bank's mobile app, the app should notify you that your credit data will be shared with the bank's credit bureau to assess your eligibility for the loan. Article number 25 talks about restriction on advertising via personal communication. It restricts the use of personal communication methods like email for advertising unless the recipient has consented and can easily opt out. For example, when you sign up for a platform like Indeed, they may ask if you had like to receive emails about job suggestions or networking opportunities or some premium services. So according to this article, the app, Indeed app, must first ask for your permission before sending these promotional emails. Also, every email should have an unsubscribe link so you can easily stop receiving marketing messages in the future and control your preferences. Article number 26 talks about personal data for marketing. Article 26 allows personal data to be used for marketing purposes if it's collected directly from the individual and they have provided consent. For example, Amazon suggests products, deals, or personalized offer based on a user shopping history. So Amazon must first obtain explicit consent to use this data for marketing purposes. Additionally, users should have the option to opt out of receiving personalized recommendation or promotional emails. Article number 27 talks about data processing for research or statistics. It allows personal data to be used for research or statistical purposes without consent if the data is anonymized and doesn't identify individuals. I'm repeating again. It allows personal data to be used for research or statistical purpose without consent if the data is anonymized and doesn't identify individuals. So it says the personal data can be used for research and statistical purposes without asking for your permission as long as the data is anonymized, meaning it can't be used to identify you. Article number 28 talks about copying official documents. This article says that you cannot copy any official documents that can identify someone, like their national ID or passport, unless it's required by law or requested by a public authority like police. So you cannot make a copy of sensitive documents like a national ID or passport unless there's a legal reason or official request to do so. For example, you can't just make a copy of someone's ID for no reason if the law requires You can make a copy. For example, when you apply for a passport, the government might require a copy of your national ID as part of the process. So in this case, copying the ID is allowed. Or if a government official like the police asks for a copy of a document as part of an investigation, they can take a copy as long as it's allowed by the law. So in simple terms, you can't copy important personal documents unless the law says you can or a government authority asks for it. Article number 29, very important, transfer and disclosure of personal data outside the kingdom. We just look only the part which is mentioned in article. There is a separate procedure document published by SDAIA. We will see these all regulatory arrangements in upcoming session. Till now about this article is when your personal data is shared or transferred outside Saudi Arabia, there are strict rules to ensure your information remains protected. There are conditions for data transfer. If a company can transfer your data abroad if it's necessary for fulfilling an agreement or meeting any legal requirements or benefiting the country. For example, if a company in Saudi Arabia needs to send your data to a foreign server to provide you with a server for a service, this might be allowed under certain condition. If your data is transferred abroad, it must be protected at a level that just as secure as the protection provided by Saudi Arabia laws. Only the minimum necessary amount of data should be shared, meaning only what is absolutely needed for the purpose. Or in emergencies like saving someone's life or preventing a serious health issue, these rules can be relaxed to allow for quicker action. For more details and elaboration, we can definitely see a separate document of procedure document about this article, and we will further see standard contractual clauses adequacy regulations about SDAIA in our upcoming session. Article number 30 talks about competent authority oversight. Whenever I'm saying competent authority here, it's SDAIA. So it's all about making sure that the rules for protecting personal data are followed. The competent authority, SDAIA, is in charge of ensuring everyone follows the personal data protection rules. They ask for your documents. They are eligible to conduct audits. They can issue fines. They talks about data protection officer, like some companies, especially big ones or those who deals with a lot of personal data. They must appoint a data protection officer. So this person, this data protection officer, will make sure that the companies follow all the rules about protecting your personal data. It also this article talks about cooperation with the competent authority. For example, if the competent authority asks for a company about how it's protecting your data, so the company must cooperate. It talks about the competent authority powers. They can request documents. They can work with some other bodies. They can monitor companies. They can delegate even their duties. So in simple terms, SDAIA is like the data police, making sure that the companies protect your personal information. They can ask for the documents, check how companies handle data, and fine them if they break the rules. Plus, they make sure that the company have the right people in charge of data protection. Article number 31 talks about when a company collects and uses your personal data, they need to keep track of how they handle it. This is to make sure they follow the rules and protect your privacy. The company must provide contact details such as person responsible for protecting your data. For example, a bank should provide the name, email, and phone number of the person who's in charge of data protection. The company must explain why they are using your data. For example, a bank may use your information to open accounts, check if you are eligible for a loan. This means the company needs to identify whose data they are using. For instance, a bank might use data for individual account holder, business clients, or people applying for loans. If the company shares your data with anyone, they need to list it. For example, a bank might share your data with credit bureau to check your credit score, or with IT service provider to keep their systems running. If your data is sent to another country, the company must tell you. The company must state how long they will keep your data. So article number 31 covers all this: purpose of data processing, categories of data subjects, entities receiving the data, transfers outside the kingdom, or talks about data retention periods. So in short, companies need to be clear about what they do with your data and follow strict rules to keep it safe. Article number 32 has been officially removed from the law and is no longer valid or applicable. Article number 33, licensing and oversight of data protection activities. It gives the competent authority a very important job in making sure public data is protected properly. Here's what they do: they are setting rules. The competent authorities, like the rule maker for all businesses and organizations that handle personal data, they set the guidelines that everyone must follow. They can issue licenses and certification to make sure companies are doing things right. The competent authority issue licenses to organizations that prove they are following the rules. They also give out accreditation certificates to data controller and processors. They are like official stamps. They say the company is doing a good job for protecting your data. The competent authority can also license auditors to check on how companies and see if they are properly handling personal data. We all see about this, how they can issue licenses, certification, audits, setting the rules in our upcoming session. Article number 35 talks about a complaint submission. It allows data subjects to file complaints with the competent authority if they believe their data under this law have been violated. For example, if you believe a company mishandled your personal data here, you can file a complaint with the relevant authority for investigation. The data subject may complain to competent authority within a period of 90 days, not exceeding 90 days from the date of the incident of the date on which the data subject become aware of it. 35 article talks about penalties for disclosing sensitive data. If an individual discloses or publishes sensitive data in violation of the law with the intent to harm the data subject or gain personal benefit, they face serious consequences. The punishment can include imprisonment for up to 2 years or a fine up to 3 years, 3 million reals, or both. So the public prosecution body in Saudi Arabia is responsible for investigating and prosecuting such violations in the competent court. If the violation is repeated, the court can double the fine even beyond the maximum limit. So this article imposes penalties for disclosing sensitive data without authorization, including imprisonment for up to 2 years and fine up to 3 million reals. Article number 36 talks about penalties for violating laws and regulation. It lays out the penalties for breaking the rules of personal data protection. If someone doesn't follow the PDPL law, they can face a warning or fine. The fine can go up to 5 million real. That's a pretty serious amount. If a company or organization keeps making the same mistake, the penalty gets worse. Repeated violation can result in double the fines. There's a committee that reviews each violation. They will decide whether the issue deserves a warning or a fine. They look at how serious the violation is and how much it affects people's personal data. The committee's decision are not final until they are approved by the president of competent authority or their representative. So in simple terms, if a company mishandles your personal data, they could face heavy fines up to 5 million riyals. And if they keep messing up, it only gets worse. So a committee makes the decision on penalties, but the president has the final say. All this is to make sure your personal data is taken seriously and protected properly. Article number 37 talks about authority to inspect and seize for violation. It gives the competent authority the power to inspect and take action against tools or equipments used in breaking the rules of the personal data protection law. For example, if an organization is caught violating the data protection rules, the competent authority has the right to inspect their tools or equipment. If these tools are being used for violation, they can seize them. This means they can take control of equipment to stop any further misuse of personal data. The president of this authority, competent authority, set the rules on how these inspections should happen, making sure everything is done fairly and in line with this law. If needed, the competent authority employees can call for help for criminal investigation authorities or other organizations to assist in their duties. So, in simple terms, if someone breaks the law when it comes to your personal data, the competent authority here, SDAIA, can inspect their equipment, take it if necessary, and even get help from other authorities to make sure the law is followed. Article number 38 is about confiscation and publicizing violation. It's about holding people accountable if they break the law. If someone makes money by breaking this law, the court can take that money away. For example, if someone hacks into a system and sells personal information, they will lose the money they made from it. The court can also order the violator to pay for a notice to be published in newspaper or other places. This is done to let people know what happened and warn others not to do the same thing. The notice only gets published after the final decision made by the court once any appeals are finished or rejected. Example, if someone hacks into a bank or sells customer data, the court can take away the money they earn from it and make them pay to publish a notice in the local newspaper telling the public what they did. So, in short, if you break the law and make money from it, not only will you lose that money, but the public will also be warned about your action and deeds. Article number 39 talks about employer disciplinary action for violation. It requires public entities to take disciplinary action against employers who violate the PDPL. For example, if a government worker at any ministry working misuses personal data, they will face punishment based on that ministry rules. Article number 40 talk about compensation for damages due to violation. It allows individuals, this article number 40 allows individual to seek compensation for damages caused by violation of the PDPL. For example, if a private company causes a data breach that leads to a financial loss for someone, that person has the right to take the company to court and ask for compensation. Article number 41 talks about confidentiality obligation for personal data. It requires anyone handling personal data to keep it confidential even after their job or contract ends. Article number 42 says that the president of the competent authorities has 2 years to create detailed rules for PDPL law, but before making those rules, the president need to talk to several important government agencies, like here the Ministry of Communication, Foreign Affairs, National Cybersecurity Authority, to make sure that these rules work well, what these groups are already doing. So the president has 2 years to put everything into place, but obviously these things will take time to develop. Article number 43 talks about says this law will start being enforced after 720 days, 2 years after it's been published in the official government newspaper, and it is published now. Announcement is we will discuss the below guidelines instruction in details about the procedure, about how we can appoint a personal data protection officer in Saudi Arabia. There are a few guidelines. It's very hard to cover all in one session. So today our purpose is just to pass through the articles, what they are just saying. I know there's a lot of details. We will further see these guidelines, how you can appoint a personal data, how licensing can be issued to audit firms, how you can transfer your personal data from Saudi Arabia to outside. We will see binding corporate rules, what are the standard contractual clauses about SDAIA, what is the personal determination guidelines, what are the breach incident, data destruction, anonymization cases, and we will see further. Today, please only ask questions related to slides. If anything is unclear from today's session, you are most likely to ask question, and we will take definitely 2 or 3, 4 questions here. And this is also a recorded session. You can also ask if anything is missing in these articles and you don't understand, you can even ask in the comment section when this session is available on the GISPP YouTube channel. Thank you.